So next up on the docket, as stated, was AB 2001. Assembly member, whenever you are ready.
Thank you, Mr. Vice Chair and members. First, I would like to thank the chair and this committee and the staff for their collaboration on this bill. I will be accepting the committee amendments. AB 2001 gives city attorneys and county council access to state summary criminal history information when they are pursuing certain public nuisance cases and actions under California's red light abatement laws, which involve illegal gambling and prostitution. This is information they can already access in other civil enforcement proceedings. AB 2001 simply extends that authority to some of the most challenging nuisance cases our local governments face. These cases often involve human trafficking, illicit massage businesses, illegal cannabis sales, and substandard housing conditions, which put communities at risk. The reality is that these are rarely isolated situations. The same individuals often appear across multiple properties. Illegal operations move from one location to another. Businesses shut down and reopen under a different name. And too often, local officials are left addressing the same problems over and over again. When city attorneys and county council bring these cases, they may know what is happening at a particular property, but they do not always have access to the broader context that can reveal repeat offenders and ongoing patterns of unlawful activity. AB 2001 helps fill that gap. By providing access to summary criminal history information, this bill gives civil prosecutors a more complete picture of who they are dealing with and allows them to build stronger evidence-based cases. That means more informed decisions, more effective enforcement, and ultimately better outcomes for the communities we serve. This is a targeted and practical measure. It does not create new penalties or expand criminal enforcement. It simply gives our local partners the information they need to more effectively use the tools they already have. Our goal should not be temporary disruption of illegal activity. Our goal should be lasting accountability and safer neighborhoods. And here with me today, we have Wade Chow, who's Chief Attorney with the San Francisco City Attorney's Code Enforcement Team, and Aaron Evans-Fudum, Legislative Deputy County Counsel.
All right, thank you both for being here today to testify. You each have 2 minutes. If you can stick to that, we would appreciate it.
Thank you. Mr. Chair and members, I'm Aaron Evans, Legislative Deputy County Counsel for the County of Santa Clara, appearing on behalf of the Civil Prosecutors Coalition. The Civil Prosecutors Coalition is proud to sponsor AB 2001. The coalition is composed of 7 city attorneys and county councils, including for the cities of Oakland, San Francisco, San Jose, and San Diego, along with the counties of Los Angeles, San Diego, and Santa Clara. We represent some of the largest public law offices in the state and advise our local government clients on all issues. We want to thank the committee and Mr. Chair for working with us on these amendments. Current law allows city attorneys and county councils to access criminal history information when they're pursuing gang injunctions, drug abatement actions, or gun violence restraining orders. Expanding this to red light abatement and certain public nuisance cases is modest and critical work. It will strengthen our cases and provide context to ensure public safety. For example, it will help us rebut defenses that problematic owners and operators can raise, such as it was a mistake or a lack of knowledge. We can confirm connections between bad actors or repeat offenders. It also helps us ensure the safety of our code enforcement staff by informing us of past violent offenses or firearm use. It offers context so we can have resources available to help identify potentially exploited individuals and coordinate appropriate interventions rather than perpetuating criminalization, such as for human trafficking operations. The amendments narrow the scope and only apply to certain public nuisance cases where access to criminal history information will allow us to determine whether additional resources are needed. These include illegal massage businesses, substandard housing, illegal cannabis cultivation, and violations of alcoholic beverage control laws. This is a narrowly tailored bill, and we urge your aye vote. Thank you.
That was exactly 2 minutes. Next speaker, thank you.
Good job.
Thank you, Mr. Chair and members. My name is Wade Chow, Chief Attorney of Code Enforcement for the San Francisco City Attorney's Office. I'm here today to speak from a practitioner's perspective about how this bill would improve our ability to protect our communities. The public nuisance work of city attorneys and county council often involves efforts to stop criminal actors, whether that's in the form of illegal gambling, prostitution, human trafficking, illegal cannabis cultivation. These cases are often complex and involve repeat actors as well as operations that easily move across jurisdictions. While we are authorized to bring actions to address these problems, we currently lack access to the same criminal history information already available in closely related contexts. As a result, we're often working with an incomplete picture when assessing risk and identifying patterns involving these offenders. AB 2001 provides a modest targeted solution. It allows trained civil prosecutors to access this information when pursuing certain nuisance abatement and red light abatement actions. I would note that this legislation does not significantly expand access to criminal history information. It does not change our ability to share this information. It does not expand the availability of remedies under these laws. A few case examples illustrate how my office would have benefited from the proposed CLETS access. We recently sued a number of businesses under the red light abatement law for offering illegal gambling. But each of these stores also was involved in other types of criminality, including the sale of stolen goods, illegal tobacco products, drug paraphernalia, and so on. Having an understanding of the players involved could have helped us investigate connections between the offenders and alert us to the need to potentially craft more targeted injunctive solutions to prevent them from repeating these actions in the future. In sum, with access to this information, we can have a better understanding of who we're dealing with as offenders, the scope of their illegal activity, and the relationships between operators. Thank you, and we request your aye vote.
Thank you very much. Any other witnesses? Okay, we'll now take Me Too testimony of anyone in support of AB 2001. Please state your name, organization, and position on the bill.
Thank you, Mr. Chair. Members, Dylan Elliott on behalf of the City and County of San Francisco, as well as San Francisco City Attorney David Chu, both in support. Thanks.
Thank you.
Good morning, Mr. Chair and members. Corey Salzillo on behalf of the California State Sheriff's Association in support.
Thank you very much. Seeing no one else coming forward to express support, we'll now take up to two principal witnesses in opposition to the bill. Before we proceed, I just want to make sure you're aware of the amendments that the author has accepted. Let me just state for the record, the amendments would limit the access to the criminal history information to public nuisance actions for illegal cannabis sales and or cultivation, substandard housing violations, illicit massage businesses, or violations of alcohol beverage control laws, and red light abatement actions. So all other nuisance cases would not be subject to the provisions of the bill. So I want you to be aware of the amendments that were taken before you proceed with your testimony.
Yes, thank you for that, Chair. I believe we are still reviewing the amendments, but I'm confident that we still share similar concerns. But to start, Chair and members, my name is Aubrey Rodriguez. I'm a alleged advocate with ACLU Cal Action. First, I'd like to apologize for filing late opposition to the author and committee. Again, as I mentioned, I think we are going to share similar concerns just with expanding access to the state criminal history information. While this proposal is framed as a civil enforcement measure, this bill raises serious concerns regarding privacy, due process, over-surveillance, and the continued expansion of this criminal history information outside the criminal legal system. Existing law limits access to criminal history information because these records contain highly sensitive personal data, including arrest information, charges that did not result in conviction, and other information that can carry lifelong consequences. Broadening the use of this information in civil proceedings that often lack the procedural protections available in criminal courts is careless. Public nuisance and red light abatement laws have historically been used in ways that disproportionately impact marginalized communities, including low-income residents, immigrants, Black and brown communities, tenants, sex workers, and survivors of human trafficking and exploitation. Expanding access to criminal history information in these contexts risk increasing consequences for vulnerable populations. Potential consequences may include eviction, property closure, or displacement, all that may happen without a criminal conviction. We have made substantial progress in recent years towards limiting the harmful consequences of criminal records and reducing unnecessary barriers to housing, employment, and stability. This proposal reverses this progress by expanding the circulation and use of this sensitive information in civil enforcement proceedings. For these reasons, we respectfully urge a no vote on AB 2001.
Thank you.
Hi, I'm Maxine Dugan with the Erotic Service Providers Legal Education and Research Project. I'm a currently working prostitute of 30 plus years, and I pretty much plan on working as a prostitute for another 30 plus more. And we did too also submit late opposition. Apologies for that. We're underfunded and unpaid and voluntary doing our advocacy, always. So our opposition is about this bill further institutionalizing white supremacy and racism, specifically because the Red Light Abatement Law, as well as the prostitution law, has its roots in criminalizing primarily marginalized people of color. And so the Red Light Abatement Law has been around for about 100 years. It was brought to a state-by-state basis because the suffragist women couldn't get prostitution as part of the U.S. Constitution to prohibit alcohol. They wanted to also prohibit prostitution, and that was not successful. So what they did is they went around on a state-by-state basis to get the red light abatement laws to try to stop prostitution by removing the places where prostitutes worked. So in San Francisco, after this law was passed in the state, over 1,000 prostitutes came to a church to protest that they had lost their housing as well as their work sites because of the red light abatement law. So, when we see that prostitution is really just, a job like any other job, the only thing that really makes it dangerous is that it's criminalized. So, we, of course, advocate for the removal of those criminal penalties as well as the red light abatement law, which shouldn't be used in this way because it's just going to further institute racism and, city attorneys to be able to target places and people that they don't like, that are culturally diverse, LGBT people, people of color. And because that's how the prostitution laws are currently being used, right? We have actual research that shows that in Los Angeles, where there was the tracking and tracing that was done by UCLA law students that showed in 2017 to 2019 that the prostitution laws were primarily used on people of color.
Ma'am, if you can please complete your comments.
Yes, thanks so much. So that's why some of the reasons why we urge your no vote and reject this bill.
Thank you very much. Is there anyone else wishing to express opposition to AB 2001?
Glenn Backus for the Ella Baker Center for Human Rights and Drug Policy Alliance in opposition.
Okay, seeing no one else come forward wishing to express opposition, I'll bring it back to the committee for discussion and just open by just providing some context on the amendments that the author has accepted. I want to thank the author and the sponsors for working with this committee the last day on amendments to narrow the scope of this bill. I think all of us who sit up here had served at some time in local government. We know that the determination of what a public nuisance is a broad range of potential offenses, going from somebody who has overgrown weeds and bushes in their yard to running a drug den. And so my concern was the original bill was very broad in nature and would allow access to this criminal information in cases where there is no criminal nexus. And so I appreciate the sponsors identifying specific categories of cases where there's a criminal nexus, where this information would be beneficial to assist in civil prosecution. I'm comfortable with the narrower scope of this bill, and with that, I'll turn it over to my colleagues if there are any questions or comments. Moved by Vice Chair Cierto. Unless there are any other questions or comments, I'll turn it back over to Assemblyman Stephanie to close.
Thank you, Chair, and again, thank you for helping us narrow this bill to something that the committee found acceptable. I just want to make sure that the committee understands that this bill does not expand the use and availability of this information for more than what already exists, and there are strict restrictions on sharing this information, and I believe the witnesses illustrated why it is so important to keep our community safe. So with that, I respectfully ask for an aye vote.
A motion by Vice Chair Ciarto. The motion is do pass as amended to the Committee on Appropriations.
82,001, Stephanie. Do pass as amended to appropriations. Araguin?
Aye.
Araguin, aye. Ciarto? Aye. Ciarto, aye. Caballero? Caballero, aye. Cortese? Cortese, aye. Perez? Wiener.
Keep that bill on call for absent members. Thank you. We'll now proceed to the next bill by Assemblymember Stephanie, file item 14, AB 2052.
Hi.
Whenever you're ready, Assemblymember, you may proceed.
Thank you, Mr. Chair and colleagues. Again, I'd like to start by thanking you and your staff for your work on the bill. I will be accepting the committee amendments to narrow the bill's provision to felony abuse of a cognitively impaired adult. AB 2052 is a measure designed to protect some of the most vulnerable people in our communities by making sure our justice system works for them when they need it most. As California's population ages, we are seeing more cases of elder and dependent adult abuse.